And I just thought about it. I was incarcerated. I got out on Thanksgiving, and she found out it was my birthday, December 12th, that she was pregnant. I was just like, that's kind of quick.
No. How long had you been incarcerated for?
I was incarcerated at that time for 90 days.
Modification and motion to confirm support of rearage. And this was filed by the Attorney General's office on January 23rd of 2025. The parties are all here on Zoom today. This is a remote proceeding, and I am sitting outside of Galveston County pursuant to the Texas Family Code, section 201.1045. I find nobody has filed any objections to proceeding in this manner. Mr. Lee, can you unmute and state your full name for the record, please?
Jonathan Austin Lee.
Thank you. And Ms. Jones, can you please state your full name for the record, please?
Loretta Mae Jones.
And can you both please raise your right hands to be sworn in? Do you each solemnly swear that any testimony you give today will be the truth, the whole truth, and nothing but the truth?
Yes.
Yes.
Thank you. You can lower your hands. And counsel for the Attorney General's office, please state your name.
Valerie Laskowski for the state.
Okay. And what is the issue today?
Judge, we are here present and ready on...
This moment right here sets the stage for the entire case. Mr. Lee signed an acknowledgement of paternity, a legally binding document, without taking a DNA test at the time of the child's birth. Legally, that's as good as declaring yourself the father, and the courts usually hold you to it. But now, months later, he wants genetic testing. The judge and the state's attorney are making it clear. Acknowledgement isn't just a signature, it carries serious consequences. Viewers, here's the dilemma. Should a man be locked into legal fatherhood just because of paperwork? Or should science always have the final say?
The state's pleadings, and there's a valid acknowledgement of paternity for the child Allison Gail Lee, born on August 7th, 2023. And Mr. Lee is requesting genetic testing for Allison prior to establishing an order.
How old is the child?
She is a little over 1.5.
You may proceed.
All right. The state would call Mr. Lee.
Yes.
All right. Mr. Lee, did you sign an acknowledgement of paternity for Allison when she was born?
That's the birth certificate, right?
No. It is a separate document than the birth certificate.
Then I believe so.
Okay. And
I think, yeah.
all right. Were you offered genetic testing at that time?
At the hospital?
Right, at the hospital.
Yes.
All right. And
Nothing really.
why did you not take the facility up on that request at that time when that was made available to you?
Me and her were together at the time, and I wasn't really thinking anything about it. I just want to make sure before I do pay child support. I just want to be 100%.
This is a telling admission from Jonathan Lee. On one hand, it sounds reasonable. Who wouldn't want certainty before committing to years of child support payments? But on the other hand, the law views hesitation with suspicion. By signing the acknowledgement back then, he essentially said, "Yes, I am the father." The judge's role here is to decide whether doubts that surface after the fact are enough to override legal obligations. Viewers, think about this. Is this genuine concern, or is it a strategy to delay financial responsibility?
And you signed a legal document that, did you sign a legal document that establishes you as the father, even though you were offered genetic testing and didn't take it? Is there any reason for you to believe that you are not her father, not Allison's father?
I just want to make sure. That's all.
All right, pass the witness, Your Honor.
Okay. You may call your next witness.
The state would call Ms. Jones.
Yes, ma'am.
Ms. Jones, are you asking for the court to order genetic testing for Allison?
If that's what he wants, yes, I 100% believe that she is his.
All right, pass to witness, Your Honor.
Sir, is there any reason to think you're not the father? I guess I'm not understanding why you would question this.
Because I was incarcerated.
I'm sorry?
I was incarcerated, and then when I got out, the time period, it just didn't seem right after I thought about it. And I just thought about it afterwards.
Here's where the case takes a sharp turn. Lee points to his incarceration as the reason for his doubt, suggesting the pregnancy timeline doesn't add up. This is where emotion meets evidence. The mother insists she's 100% certain, while Lee paints a picture of suspicion fueled by circumstance. But here's the thing, biology doesn't bend to speculation. Either the timeline works or it doesn't, and the DNA test will resolve that. Until then, this becomes a battle of credibility, whose story seems more believable to the judge.
And I was like, okay. I was like, because I already knew this day would come. I just been waiting on to get served with the child support papers. And I just thought about it. I was incarcerated. I got out on Thanksgiving, and she found out it was my birthday, December 12th, that she was pregnant. I was just like, that's kind of quick, but it's not impossible.
No. How long had you been incarcerated for?
I was incarcerated at that time for 90 days.
Okay. And when she found out she was pregnant, she was newly pregnant, or what? Do you know what trimester she was in?
I do not remember, to be honest with you. I do not.
Okay.
The main thing for the genetic testing, I just want to be 100% sure before I'm court ordered to pay what the lady before told me.
Okay. That's not really a basis.
And there it is. The judge cuts through the noise and grants the genetic test. This decision strikes a balance between legal formality and biological reality. For Lee, it's a victory, at least temporarily. But here's the catch. While he's bought himself time, he's also triggered a reset that pushes the case months down the road. That means added stress, delays in financial arrangements, and continued uncertainty for everyone involved, especially the child. Viewers, was the judge right to prioritize proof over paperwork? Or should the acknowledgement have stood as final?
To do the genetic testing, so that's why I was asking if there was a different reason. Ms. Jones, do you have a response to his reason?
No, ma'am.
Okay. In light of the testimony presented, I'm going to grant the genetic testing. What reset date do you want to use?
November 12th? I'm sorry, November 10th? November 10th
Whoa,
at 8:30.
It's going to take us 6 months to get testing back?
No, Judge, but Mr. Lee does have a new child due in October.
Okay, well, I did not know that. So please, when you do dates that are really far out, let me know why, because that's
okay.
I don't want to get in the habit of setting things 6 months out. So your child is due in October?
Yes.
Okay. Everyone really needs to be ready in November because that is a long reset. So if anyone has, sir, let me talk. If anyone has information about insurance for this child, through jobs, through other sources, whatever you're doing, please bring that with you. Breakdowns of costs of that insurance. If you're all addressing back child support and you're all going to claim you've been paying or not paying, bring evidence of that as well so we can proceed. Sir, if you're working, please bring tax returns, pay stubs, information so we can do accurate child support. If there's any witnesses you're all going to want to...
This is a critical point in the hearing. The judge isn't just thinking about DNA results. She's laying the groundwork for the financial realities that will follow. Insurance, child support arrears, tax returns, everything must be on the table. This highlights a brutal truth about family court. Paternity is only step one. The real battles are often about money, responsibility, and the child's well-being. Think about it. How many people walk into court thinking it's only about biology, but walk out realizing it's about the long-term economics of raising a child?
Call because visitation or custody is an issue. Please have those ready to prepared to be here on Zoom that day, because that is a long reset. So usually, you come again, and if there's issues that bubble up, I'll give you time to prepare. I don't think you're going to be able to get that because this is a very long reset. Okay. Does anyone have any
and
questions? And what was that date again? November?
10th, Judge. And in the interim, the state would also request that the court order Mr. Lee to participate in the Choices program through the Texas Workforce Commission.
Is he working right now? Can you present some testimony on that issue?
Yes, Judge. May the state briefly recall Mr. Lee?
You may.
All right. Mr. Lee, are you currently employed?
No, ma'am.
Why not?
Right now it says getting a job. I have a deferred felony from running on a motorcycle from the cops, and to get any decent job to where I could still pay the child support that I have on mine and Lori's other daughter, and also still like afford gas to get back and forth to work and everything else. It's very hard to get a decent job because right now, like all the jobs that I guess you would call it a second choice, besides like McDonald's or something like that, aren't really hiring. Like I tried to get a TWIC card, I got denied. Tried a couple other places, like the boat, working on boats, and I can't do that because I'm restricted to Galveston County. I have to have a release note to be able to go work out of like town, out of state, stuff like that. So it's been a handful. I will say this: I should be getting off probation this year. I just don't know when.
This testimony adds a whole new layer. Lee reveals that his criminal record and probation makes steady employment difficult. He paints himself as willing to provide but unable to land a decent paying job. The judge and the state push him toward the Choices program, designed to help parents like him find work despite legal barriers. But here's the hard question. Does his past excuse him from present obligations? Or is this just another delay tactic while the child's needs continue without consistent support?
And after that goes into place, I will most certainly, I'm like 85% sure right now that I will have a job at a place called CertCorps, and they do pay decent. At that point, I would probably get a hold back with y'all so we can do a reset on pay, because if I'm paying child support on minimum wage, I just don't seem like that's right. I should provide the actual statements and pay stubs.
All right. And Judge, for that reason, the state would ask the court to order Mr. Lee into the Choices program, as the Choices program does have experience working with individuals with criminal record barriers to employment.
Okay. Before we get to that, I heard you say you have another child with Lori. Is that Miss Jones here?
Yes, ma'am.
Do you have a court order with you and Miss Jones over another child?
Yes.
What county is that order out of?
It's this order, Judge. This is adding. This is
is
an establishment of an additional child to a previous order. Yes.
And there it is. The judge cuts through the
I'm
testimony,
grant
the
DNA.
accusations, and the emotional back and forth to make a ruling. $456 a month in child support, plus $75 for medical coverage. A compromise rooted not in promises or allegations, but in the numbers presented under oath. For the mother, it's less than she hoped for. For the father, it's more than he wanted. For the children, it's a step toward stability. This case shows how family courts wrestle with messy financial realities, competing narratives, and the challenge of fairness when the truth is clouded by conflict. What do you think? Did the judge get it right? Should verbal promises hold more weight, or was the ruling fair given the evidence? Let us know in the comments. And if you found this breakdown as eye-opening as we did, make sure to hit that like button, share this video, and subscribe for more jaw-dropping courtroom showdowns.